Justice Mr. Bin Chan, Judges of the Court of Appeal, Chief Parliamentary Counsel Mr. Cecil Durjon, Solicitor General Mr. Sitaram Lal, Project Coordinator of the Modernization Justice Administrative System Program, Country Representative IBB Ms. Sophie Buchanan, distinguished ladies and gentlemen of the legal fraternity, special invitees, members of the media, a very good afternoon to you. My name is Indira Ananjit, and I'm the Permanent Secretary of the Ministry of Legal Affairs. I am going to be your chairperson for this afternoon's proceedings. First of all, I would like to welcome you to this very important exercise for us at the Ministry. We are gathered to witness a very important activity, and that is the launching of the Guyana Law Reports. No doubt this is not the first, but we cannot underestimate the importance of having written judgments which were considered worthy and important by our High Court and our Court of Appeal. Therefore, all litigation from 1997 to 2007, given judicial precedence by way of written judgment and forming a record for our legal professional and other interested persons, hence we have these reports today. It is imperative that not only do we have information, but it must be accessible to all. It is against this background that you will hear more about this exercise from those who were integrally involved from its inception to where we are today, that is, getting the reports printed and being made accessible to everyone.
Representative and members of the staff of the IBB, Honorable Chief Justice, Judges of the Court of Appeal, Chief Parliamentary Counsel, former Attorney General, and Minister of Legal Affairs, Charles Ramsden, Madam Solicitor General, Judges of the High Court, Permanent Secretary Muller, distinguished members of the legal profession, members of Parliament, ladies and gentlemen. As project coordinator of the Modernization of Justice project, I thank you for your attendance this afternoon at this ceremonial launch. It is said historically that justice is old-fashioned, in that it claims the century-old procedures. The Modernization of Justice project, by its very name, implies the intention to don the coat of modernity and sweep away the cobwebs of the past generations which enmesh our legal system, making it inappropriate for the 21st century. At the heart of this program, there is a move to dispense with archaic procedural laws, bringing Guyana in line with modern international standards, trends, and best practices. The Modernization of Justice project, as we all know, is fully funded by the Inter-American Development Bank by way of a loan to the government of Guyana, and all related expenses for this project, including the launching, is being met from funds from the bank. We are therefore grateful to the IB for its continued support to Guyana, and in particular to this project, and for the opportunities afforded to the people of Guyana for a more efficient and transparent justice system. Today, we are particularly pleased to have with us Madam Sophie Buchanan, the country representative of the IBB. Madam, we are indeed very honored to have you in our midst. And thank you for the interest you have shown in the activities of this project. Last June, you journeyed with us to Letland, where we launched our first paralegal and today you're once more with us. We, the officers of the Technical Secretariat, would wish to say a special thank you for the excellent leadership skills you have displayed in solving bottlenecks for the smooth running of the project. We thank you. The Technical Secretariat is also grateful to Mr. Alexandra Vera Conte, the international specialist with oversight responsibility for this project. Mr. Conte has ably assisted in chartering the course of direction for this project. With him at the helm through turbulent waters and rocky ground, we were able to moor the ship on its correct state of the course of destination. To the senior members of staff of the IDB, Ms. Doris Williams, Ms. Leslie Ann Edwards, Mr. Richard Rado, who interfaces with us on a daily basis, we say thank you for your patience. The contract for the law reports was awarded through a competitive process to a Canadian firm, Lexo, in the year 2010. Members of the firm, with the cooperation of the Honorable Chancellor, set up a workstation at the Court of Appeal, where all the Cyprus-style decisions for the years 1977 to 2007, that's 30 years, were scanned. And at this point in time, I must say a special thank you to the librarian of the Court of Appeal, Mr. Mon, who made those decisions available to the team. Because at that time, we were not able to allow the decisions to be taken out of the country because those decisions were needed for the use of the judges in the Court of Appeal. Now, as we members of the legal profession are fully aware, our courts did not have any computers in the 70s, even in the early 90s, 70s, 80s, 90s, we had no computers. So the decisions of the court were typed and stenciled, and therefore we had Cyprus-style copies. Those were the copies which we had to use. We had to have them scanned. And the scanning, I can tell you, was not without problems. At the end of the process, some of the words were indecipherable. Since the consultant, well, as I said, the consultants were not able to take the originals. So on receiving the draft reports, many errors were discovered. And therefore, myself and then Justice Ramsden, the Attorney General, we were going through the draft reports trying to correct errors. But the errors were so many, because one time even Justice Ramsden remarked that, look, I corrected this some time ago, and look, we still have the error here. So through the IDB, we were able to hire some proofreaders, and we were ably assisted. Today we are launching the law reports for the years 1977 to 2007. These are in print, they are open. The last law report for the year 1976 was printed in 1996, some 20 years after, by a joint Lions Rotary funding, spearheaded by former Chancellor Bishop, assisted by a battery of young attorneys. So everyone who assisted us in this important exercise, I say a special thank you. The project has also expended resources on Alexido software. This is an electronic document management platform specifically designed to generate and support websites. The law reports of British Guiana and Guyana for 1930 to 2007 were processed on this software and can now be viewed online. there will be a demonstration after we will finish the speeches. In addition, two of MOLA staff, Mr. Mark Mohabir and Mr. Ray Mohammed, were trained by Lexum to sustain the online system and to add on new decisions for the succeeding years. We have indeed come a very long way from the days of cycle-silent judgment. This is indeed a great and important achievement. Today, 16 years after our last law report was printed in 1996, we have printed 200 sets of 14 volumes per set for the years 1977 to 2007. One of the project's key objectives, that is access to justice. Today, His Excellency's launching of the law reports is no mere formality, as we all know that His Excellency will embrace whatever is progressive and in the interest of the citizens of Guyana to have access to justice. Thank you.
At a most momentous occasion. Since the beginning of society, man has been engaged in a singular quest, and that is in search of justice and freedom. In our living memory, the persons who have dominated space universally, Mahatma Gandhi, Martin Luther King, Nelson Mandela, in our own country, Cheddar Jackson, they have all engaged in one singular search for justice and freedom of people. And that is why this administration places so much importance on the judicial sector. We in the executive are of the firm view that we will not progress as a people, we will not advance as a nation, we will not develop as a society if we do not have a system that guarantees justice and freedom to our people. Denial of justice and the threatening of justice and the threatening of freedom everywhere. And that is why the government will continue to persevere to ensure that the rights of the people, especially those in the National Assembly, are enjoyed. It brings me to the topic at hand, the law reports. The law reports in any society is very instrumental to the development of jurisprudence, to the development of the law, and to the advancement of justice. That is an undisputed fact, and that is why every country has ensured that their law reports are there and judgments given by courts are kept in a permanent form, because ours is a legal system which embraces a principle that courts must act consistently and must act in accordance with certain principles of stare decisis and so on. So it is important that we have a record of what is decided by our courts, so that the people of the country, most importantly, can be assured that justice is not an erratic thing, that courts are going to act with uniformity and consistently, so that you can have predictability in society. Hence the importance of this report, these reports. And you know, we have had many lapses in the preparation of our reports over the years. We have now of about 36 years law reports, and it is not going to end there. We intend to have this exercise as a continuous one, to ensure that the law reports, we continue to have them and to publish them. We would have from 2007 to 2013 a gap of about 5 to 6 years to fill, and we intend to fill them. In addition, we also have the online version of these reports, but fundamentally, they date back to 1932. So that every single Guyanese who have access to the internet can go and can read our decided cases and see how our courts have decided cases going back to 1932.
Former Attorney General, distinguished ladies and gentlemen, all. I'm very pleased to be associated with this event this afternoon, and I consider it a very important day for our country. But here we are launching or bringing up to date as far as possible our law reports. I see as a major tool for the judiciary to perform their duties in bringing justice to our people. Brings all of these reports and these volumes here. It also makes it easier for researchers generally and for students, law students and other students, to research many of these cases that have been heard in our court and that can be used as precedent in other matters. Over the years, that the Attorney General mentioned just now, we have been taking steps to improve the conditions in the judiciary, to make it efficient, and we have done a lot as far as the physical accommodations are concerned, building new courts, renovating them, and also bringing them into the modern age with information technology and other facilities to help them discharge their duties. I will not be saying anything new. In fact, the Attorney General just mentioned it here, that there is a direct link and direct connection between socio-economic development and a strong, independent judiciary. And I want to say very, very clearly that this government believes in that, and we have done everything to ensure the independence of the judiciary. And although we have been accused of many, many things, I don't think anyone can accuse us of interfering in the work of the judiciary. In business also, it is very important that we improve the quality of work and the speed at which we work. It is important that people, these are some of the complaints that I have heard myself, that people complain that sometimes they take an extremely long time to get decisions, judges' decisions in writing. And that obstructs, probably that is one of the reasons, and this is where the judiciary can help us, because one of the reasons our country probably is marked down a bit low in terms of competitiveness has to do with some of these things. And we have passed legislation so that we can see, asking that these judges write their decision in a timely manner so that it will not delay justice, or if people want to make an appeal, these things are important for them to do so. Unfortunately, that piece of legislation has not been used. I'm told that I've just been whispered to that there might be some problem with it, but that's the first time I'm hearing about that. But I think that it should be used because our people deserve to have these decisions known in good time. So I think that's one important area that we can have, we can see. And even if we didn't have legislation, even if there's some problem with the legislation, I believe it is the duty of a judge to deliver those decisions in writing so that people can take whatever appropriate action needs to be taken with that. What mentioned just now too, we are working towards increasing the complement of judges to deal with the backlog. Because personally, it grieves me sometimes to know that people are incarcerated for long periods of time without having an opportunity for their cases to be heard. And it's very, very clear that there is great room for improvement in this regard, and to try to make justice swifter. The old saying, justice delayed is justice denied, and we have to improve the conditions there as well. As I said just now, I'm a strong believer in the independence of the judiciary, and that clearly means that the judiciary must deliver justice fairly, without any undue pressures from any side, and the rulings should be, or must be, in accordance with our Constitution and our laws. And I have had a sneaking opinion for quite a while now that many of the decisions that we see in our courts, particularly as it relates to the state, I was often getting the impression that some judges, in order to want to try to demonstrate their independence, sometimes feel that they have to rule against the state. Now, I was reluctant, and I never expressed this view before in public, but I found authority that emboldened me today to raise it, because I found an authority that expressed a similar view, and I would like to read it for you. It was in a colloquium held in 1998 in the United Kingdom. And the judge, I think his name is Khanna, yes, Justice H.R. Khanna of India, made this remark in his presentation at that activity, and I will read it for you, not a long piece. And while talking of the independence of the courts, I must remove a misconception. Independence of the courts does not necessarily mean deciding a case against the state. He went on to say, sometimes a notion prevails. The more a judge decides cases against the state, the more independent he or she is. This is a wholly misleading notion, and the sooner it is dispelled, the better it is for the health of the community. Exactly my feeling, but it continues. Every government in a welfare state has to undertake a number of measures with a view of bringing about socio-economic reforms. The modern approach is that the welfare of the community must have primacy over the private rights of the individual. We, therefore, should not take a lopsided view of the independence of the judiciary. Independence postulates keeping the scales even in any legal combat between the rich and the poor, the mighty and the weak, the state and the citizen. As much as justice can be done by keeping the scales weighed in favor of the citizen and against the state, as it can be by keeping the scales weighed in favor of the state and against the citizen. Now, this has been a view I've had a long time, but I've not been a legal person. I didn't attempt to express it publicly, but I now have good authority in expressing that view that justice should be blind, and justice, it should be upholding of our Constitution and upholding the rights of our citizens. So that is what I would, and that is giving this, I think, this opportunity to express those views today, because, as I said, for some time now, I've been having this view. As far as the e-Gazette is concerned, I think this is also very important for us at this point in time to have modernized this, because many ordinary people never take the time to go and buy the Gazette and go through all of these things. And we are trying our best to ensure that people who are sometimes not in the best of economic circumstances are not disadvantaged. And that is part of the reason that we have this program, the One Laptop program, to ensure that everyone got access to information technology and can, without taking no regard for their economic circumstances. And putting the Gazette online will help a lot of people, a lot of poor people, many of whom sometimes lost their property without knowing that they have lost their property, largely because they didn't have the time, or they didn't probably even know where to go to get the official Gazette. Now, this, I think, is a very important part in safeguarding their rights. It's also safeguarding the rights of many Guyanese who live abroad. Come to me for one reason or another from time to time, to while they have been abroad, they have lost their property. And now they will have an opportunity, no matter where they are, once they have property here, that they can look and follow in the official Gazette to ensure that their rights are also protected. So I think that this too is a really momentous day as far as making all of these things available to all our people, so that they can themselves empower them, to use the term used very much today, empower them to be in a position to defend themselves and to have information, most of which sometimes they feel they never had access to. So once more, I'm very happy to be part of this activity here today, and to wish that these new tools that have been given to the judiciary will improve the functioning of our judiciary, and in the final analysis, improve the quality of life in our country. Thank you for your attention.